Good afternoon, everyone. Thank you so much for joining us for another webinar this week. Just a couple housekeeping items. If you have questions, you want to type those in the question box, which is on the right-hand side of your screen, and Mike will answer those at the end of the webinar. And we're asking you to give us 5 to 7 business days to record your CEU on the portal. This law CEU is always a largely attended one, so it does take us some time. At this time, I'd like to welcome our Executive Director, Mike Linati, for Public Disposition, New York State Public Health Law, Section 4201. Thank you, Mike.
Thanks, Kelly. Good afternoon, everybody. Thanks for taking the hour to join us here today. As we typically do, we will end the actual presentation a little bit before the hour's up to give you a chance to ask questions. This is, as Kelly mentioned, one of the more popular topics, not just in terms of the webinar, but Kelly can attest to this as she handles the majority of the compliance calls that come into the association. Still, final disposition is by far and away the most popular reason that we get a compliance call. So we have some scenarios that we'll go through with you just by way of example of things that we've come across. And like I said, we'll leave enough time at the end because we figure there'll be some questions that you guys might have for us. So without further ado, let's get started. Oh no, what is going on? All right, having a problem fast forwarding. There we go. So just a quick overview for you. So as many of you probably know, this is not, I guess, by terms of New York State law for funeral service, this is not an old law. This is actually one of the most recent laws that are on the books. The law became effective in 2006. It has been amended 3 times, the most recent of which was this year, and I will go over what that change was during the presentation. When this was enacted, there were 4 main reasons or purposes for putting this law in place. The first, and the one that is talked about the most, is the priority list, or we call the next of kin hierarchy, that the law sets forth. It was also to allow an individual to appoint the agent or a legal representative to control their final disposition. We also wanted to ensure there were liability protections for both anyone accepting their role as an agent, as well as our funeral directors. And lastly, we wanted to have provisions that talked about how to handle dispute resolution. So in a lot of ways, this turned into and became a roadmap for funeral service. So again, just a little bit more on the background, which I'm sure many of you lived through. But prior to this law, our funeral directors had to deal with questions of who controls a person's final disposition. Increasingly, funeral directors found themselves in the middle of a disagreement, a dispute among family members, both as to the method and potentially the procedure of a loved one's final disposition. In addition, the landscape has been altered by the complexities and realities of today's society, which includes more non-traditional family structures. This factor presents emerging legal and practical challenges for funeral directors, who are also looked to by the deceased survivors to make the decision as to which of them has the legal authority to control their loved one's final disposition. However, as you're very familiar, each situation is unique, and funeral directors are not always made aware of all the facts in a particular case. It's also extremely important to note that prior to this law, New York State did not provide funeral directors with any specific guidance as to how to handle these situations or any explicit legal protections when doing so. As all of you know all too well, funeral directors are often put in an uncomfortable position of taking sides with one party over another, and by extension, seemingly endorsing a type of disposition that could ultimately be found to be contravene the wishes of either the deceased or the loved one possessing the actual legal control. Of course, the irreversible finality of cremation raises the stakes even further. So needless to say, such a role goes well beyond a funeral director simply acting in the less risky, albeit important position of mediator or arbiter. Unfortunately, these situations and circumstances cannot be avoided, but thanks to the final disposition law, funeral directors have heightened levels of clarity in dealing with family disputes, as well as significant liability protections that have been non-existent prior to this law being enacted in our state. So I'm going to walk through this. Just a quick, I've said this before, sometimes when I do my law presentations, a little bit of a disclaimer. Since we are reviewing the law, I'm going to go through the statute. I want to make sure that I am covering the words as they are written in the law. So I will probably read more on my slides than I normally would. I'm also going to go through the final disposition law, which, as you saw from the first slide, is section 4201 of the public health law, section by section in the order it's set forth in the law itself. So it may seem a little different than how it's been done in the past, but again, I want to walk through it for you the way it's set forth in the law. Okay, so the first section of the law, as most laws do, have defined terms or definitions. There are only there's only 3 defined terms for the final disposition law. So we're going to take a look at each of them. The first one is the term disposition itself, which is defined as the care, disposal, transportation, burial, cremation, or embalming of the body. So when we talk about the person in control of disposition, technically those 1, 2, 3, 4, 5, 6 things are the things that that person is actually controlling. The next definition is domestic partner. Obviously, this is one of those things that comes up in our calls and questions that we get. So it's important to know what a domestic partner is. So a domestic partner is someone who to another person is either formally a party to a domestic partnership. If that is the case and you are in a domestic partnership, you would actually have a certificate that would be issued to you once it's approved by the state of New York, which could happen. It's not often the case, but there is that possibility. Or those folks can be registered as a domestic partner. Registration is available at the state level, at the New York City level, at most county levels, and there are even some towns and other smaller municipalities that allow two people to go in and register as domestic partners. So that's if you did one of those 2 things, became a party to a domestic partnership agreement or registered as a domestic partner, the individual coming in saying they are the domestic partner would actually have a document in hand evidencing that domestic partnership. A third way they can do it is if you're named as a beneficiary or a covered person under the other person's employment benefits or health insurance. The reason for that is normally if you're going to be named that way, you're typically already have a relationship like a domestic partnership. So they can just present that evidence of being the beneficiary to show that they are the domestic partner. The last one is the one that most of us deal with when we have someone tell us that they're domestic partners, and that is where you find that they are mutually interdependent on each other for support based on what's referred to as the totality of the circumstances. The unfortunate part of this is that there is no clear, bright line definition or list of things that if you can check all the boxes, you're definitely going to cover everything. So it can be 1 or 2 of these things. It can be all of these things. It can be 3 of them. So it really depends on the individual circumstances. But the things that are looked at are the things that are in that list that are checked off. So the more of these things that they have, the more likely they'll be able to prove they're domestic partners. So if you're common owners in property, home, something along those lines, you have a common household. So again, it's not that you own the house together, that's the first one, but you live in the same house and you're actually creating a household together. If you're sharing your income or expenses, if you've had children together, if you are intending to get married, so you're engaged, you have plans, you have filed an application for a domestic partnership, those are things that would also be signs. And then the length of the relationship. The longer that folks have been together, showing that they intended to be acting as domestic partners, the more likely that they are going to be able to defend that position, or the person who's coming in saying they were the domestic partner of the deceased will be able to defend that position. Now, Important to note under the law is that you as the funeral director are not required under the law to obtain proof of a domestic partnership. So just so you know, if somebody comes in and says, I'm the domestic partner, you don't have to get proof of any of these things under the law itself. But we'll get into a little bit more of that as we go forward. So that's what a domestic partner is. And the law also talks about what a domestic partner cannot be. So even if you were showing 4 or 5 of those other things I just talked about with the check marks, if any of these on this list are in place, by law, you cannot be a domestic partner. So this is really referred to mainly as the anti-incest rule. So if you're related by blood or marriage, you cannot be a domestic partner. If you're under 18 years old, if you're an adopted child of the other person, or if you're related by blood in a manner that would bar marriage in New York to the other person, then you're not going to be able to be domestic partners. It kind of makes logical sense, which the law doesn't often do, but in this case, you can understand why they would be clearly saying why you could, in situations like that, you could not be someone else's domestic partner. And the last thing that is defined is person. So again, this kind of goes into the cannot be under 18. So if you are going to be a person under the law, the final disposition law, you have to be 18 years or older. So minors would not be deemed people for purposes of being able to control disposition. Okay, so now we're going to move into the priority list. I will tell you that this is the most often relied upon section of the law and the area that we get the most compliance calls in. All right, so I guess I will just mention here that the information that is highlighted and underlined in that's underlined, I should say, and italicized, that is the change that took place this year through the law amendments. So let me just go through the first, just the overall, and then I will talk about the actual specific change that took place. So when you look at the law, it will read that these following people in descending order have the right to control disposition. So if you're number one, higher up you are on the list, you're the person who's going to control. So the law that was changed, or the language that was added, says that provided that if there are more than 2 members of a class listed in subparagraphs 3, 5, or 7, which I've highlighted for you on the list, then the folks there, you would have to have a majority of the members of that class who are reasonably available. So what does that mean? So let's go to number 3, any child 18 years old or older. If you have 3 children and they're all 18 or older, you need 2 of the 3 to agree as to what type of disposition will take place in order to move forward. And it's same with siblings. If you had 5 brothers and sisters, you need 3 of the 5 to agree. So that was the change in law that was put into place in 2022. So now let's just, the list itself has not changed in terms of the priority order. So walk our way through that list. Number 1 on the list is the agent. So we'll go through the agent form a little later, but if a person is named as the person in control as an agent through the agent form or through a will, then that is the person that you're going to go to. They are the one who will always have control of disposition. Working your way down the list, if there is no agent, then you go to a spouse or domestic partner in the law that's listed as 2 and 2A. So they're sort of equal footing because you're only going to have one or the other. Then you get to a child who's 18 years old or older, either parent, then any sibling 18 years or older. Next would be a legally appointed guardian. Next would be any person entitled to share in the decedent's estate. I will get into some more details on that in just a second. Then a duly appointed fiduciary of estate. Then a close friend or relative who's reasonably familiar with the decedent's wishes. And then finally, the public administrator or anyone willing to act on behalf of the defendant. I'm just going to take mention a couple of things here. So going back to spouse, back in 2011, New York State passed the Marriage Equality Act. So that now means that same-sex spouses are included in in the term spouse. So it's not just heterosexual couples, homosexual couples that are spouses are also included in this law. Number 3, where it says any child 18 years old or older, just so that you know, stepchildren are not considered children for purposes of the final disposition law. So it's actually got to be someone who is legally adopted or someone who's blood related. Stepchildren are not children who would have rights to control under this law. When you talk about parents, we've been asked about foster parents. Foster parents are not included in this list or in that definition. So a foster parent is not a parent entitled to controlled disposition. A foster parent can become one if A, they legally adopt the child, in which case then they are a parent, or if they are officially appointed legal guardian of somebody, then they fall under number 6. But if they're just fostering the person, then they would not be in control of disposition. The last thing I'd like to just mention before I get into the asterisks that are on this page is power of attorney. So we get that question a lot, whether the power of attorney can serve similar to like an agent would be able to. So a power of attorney is not on the priority list. You don't see where it says power of attorney listed anywhere on this list. If somebody appoints another as their power of attorney, then, and it's been a, I'll call it a general or full power of attorney, as opposed to one where you check the box and say, you're in charge of my banking transactions only or my real estate transactions. If it's a general power of attorney, then that person can step into the shoes of the person who would appoint. So let me make it a little easier. So let's say that I appoint Kelly as my power of attorney. So now Kelly can go ahead and appoint someone to be my agent in control of my disposition. She cannot appoint herself, but she can appoint somebody else. And she herself, simply because she's my power of attorney, does not fall anywhere on the priority list. It's a question we get a lot about, calls about. I just want to make sure that everyone knows that how that works for purposes of a power of attorney. Okay, so let me just touch base on these asterisks because there's another layer underneath these lists that talk about it. So let's take the first one, any person entitled to share in the decedent's estate. So now you have to go down into more details for that. And now it's the people entitled to share in the decedent's estate in a very particular order, which is listed here. So if you get all the way down the list, because there's no agent, no spouse, no child, no parent, and no siblings, and no legally appointed guardian, now you're down to this. And then you got to find out if that person had grandchildren, because they would control. If they don't, then you get to great grandchildren. If there's no children or great grandchildren, you get down to nieces and nephews, and you can see how the list goes on and on and on. But there is another whole list underneath number 7 that talks about the people entitled to share in the decedent's estate. It's a very specific list in priority order all by itself that you'd have to know about. The other double footnote or the double asterisk is relating to both number 9, which was close friend or relative, and number 10, who's a public administrator. So if you are that close friend or the public administrator, the other condition there is you will not be entitled to serve as the person in control of disposition unless you complete the at-need written statement of a person having the right to control disposition. That is different than the appointment of agent form, which I am going to go over shortly, but the at-need written statement, which I'm sure you're all familiar with, those last 2 categories, that person absolutely positively has to sign that form in order to move forward where they can. So let's see, I think that is everything I wanted to mention on that. So I'm going to move on to the last part of this, which is what the law next does in this section is it addresses some what if scenarios. So I want to just walk through some of them with you. Okay, so you now, let's say you found that the person didn't have an agent or a spouse, but you find out that they had a son who is 25. Now you have to go and you find that person, but does that person have to take their responsibility to serve in that role? They do not. If you can't reach that person, what are you supposed to do? So what the law said is if someone is unavailable, unwilling, or not competent, then you go down the list to the next person on the list. Or in the example I gave you, let's say there was a son and a daughter, you would then be able to go to the other person on the list because with equal priority because that person was unwilling, unavailable, or not competent. As it relates to unavailable, the law specifically says or reads that if the person is not reasonably available, quote unquote, that is when you would move on to the next person. So what they're basically saying is it's a reasonableness standard. And under the law, when you talk about reasonableness, you're going to ask if you can get that person's email address, a phone number, do they have an address that you can get? And you're going to try to reach out and see if you can make contact. It does not mean you have to go out and hire a private investigator to go and find this person because you heard that they have a son who's 25 years old. So again, it's just a reasonable effort to try to find that person. If you can't, then they're deemed unavailable under the law and you move to the next person. So the next piece that the law talks about here is the duty of the agent or person in control. So what is their responsibilities? Their responsibilities are to carry out the decedent's wishes to the extent lawful and practicable. And in doing so, they can consider the financial capabilities of the decedent's estate and any other resources available. And they should act in a way that is consistent with the decedent's moral and individual beliefs. So I have a court case that I'm going to share with you guys that will help explain what this is all about. So this is a case it was in New York Supreme Court in New York County, so down in the city, back from 2017. And here's what happened. So a woman died, leaving no specific instructions about how she wanted to be buried. She had been divorced twice from her children. She was divorced twice from the same person who was her children's father. She had purchased a cemetery plot with him way back when she was married to him. So her surviving adult children were the legal next of kin and by law the first in line to control her final disposition. After her former husband's death, she went with her sister and purchased a cemetery plot in her family's home country of Israel. In the years immediately before her death, she had continuously expressed her desire to be buried in Israel. She told both her sister this, as well as her home health aides. And she did not put any of this in writing, but she did provide her adult children with the information relating to her newly purchased plot in Israel. The children wanted to bury their mom in the plot she had purchased with her ex-husband, their father, which was located in New York City. The sister went to court and petitioned the court to override the kids' decision to have their mother interred in New York City, arguing that they were knowingly going against what their mother had been telling others. So the court then held hearings where they heard from the children, the sister, and the health aides. And then after hearing all of this, the court ruled that the decedent could be buried in Israel. And the reasoning was that the children's testimony focused primarily on what they thought their mother would say or do, rather than what she actually said. So as such, it did not represent personal and direct knowledge about their mother's wishes. Yet the home health aides testified that they had actual conversations with the decedent where she clearly expressed her desire to be buried in Israel. So why is this case important? Because it was the first case in New York that dealt with this law, and it really reiterated the underlying key messages or behind the law itself. What are those messages? So it's basically that the law provides a list of people responsible to carry out the wishes of the decedent, which we knew because it was the children. The survivors have the responsibility to try and fulfill the loved one's wishes. The decedent's wishes are paramount to the survivor's preferences. that anyone with knowledge or evidence that the legal next of kin is acting explicitly against the decedent's wishes may petition the court to halt the disposition. That a person's competence, remember I just said that they're not competent, that you go down, a person's competence to act relates to their ability and willingness to carry out the decedent's wishes to the extent they are known. So for example, if someone's deemed incompetent, it might be that they've had a health issue and they're no longer able to act. But it also could be that they're just not willing to carry out the decedent's wishes that they know that they want to have carried out. Last 2 points that were reiterated about the law was when someone is unwilling or unable to carry out the wishes of the decedent, the court must proceed to the next applicable person on the hierarchy list. And then lastly, the person in control of disposition must faithfully carry out the directions of the decedent in a way that's in line with the moral and individual beliefs and wishes of the decedent, which is what I mentioned on the slide. So important takeaway, and something that we always recommend, is that whenever there is evidence of a family dispute, or if the funeral director has knowledge or reason to believe that the legal next of kin is not acting in accordance with the decedent's written directions or expressed wishes, we always recommend that you pause and direct the family to get a court order to tell you how to proceed. So again, just want to make sure that you're aware of that case, because it really does kind of summarize a lot of what the last 2 slides that we just went through cover. Lastly, with regard to this piece, just keep in mind that a person who's in control by 4201's hierarchy is not liable or responsible for paying the funeral expenses just because they are the agent or the person in control. So many times it will wind up being one and the same person, but legally, the person who's in control is not responsible for paying the bill. All right, a couple more subsections in the law to part 2. The first is, can a funeral director be a person with right to control? So the answer is yes, if there's a but. So a funeral director, if they are going to serve as the person with the right to control disposition, can do so, but you cannot receive any compensation or a financial benefit for doing this role. So just make sure that if you are in that situation, that you know that you can do it, but it's got to be at no remuneration to you. Lastly, there was one other change that was, I mentioned there were a couple of changes made to the law. The one in 2012 was an amendment known as the Anti-Domestic Violence Law. So this put in place that in certain circumstances, even if you are under the hierarchy list, the person in control, you're going to not be allowed to serve in that role. And that's when you have orders of protection. So you're prohibited from serving as a person in control if either of these 2 things are in place. You're subject to an order of protection at the time of death. So the person who died had an order of protection against you, the person in control, or you've been charged with the decedent's homicide. It's important to note, because this has come up as well, if you're arrested only, I shouldn't say only, but if you're arrested but not charged yet, if you're a suspect in an investigation, those are not enough. You actually have to be charged with the homicide in order for this provision to kick in and you to be barred from serving in that capacity. Can this be waived? Yes, the court can waive it through a decision or an order if it is, quote unquote, in the interest of justice. So I have one more case that I can use and go over with you to explain how this piece worked. This is a case from 2020 up in the county of Washington, so in the North Country, around the Adirondack region. So the case here's the facts of the case. So a wife died in December of 2019 and is cremated. Her ashes were given to her daughter because the wife had an order of protection against her husband at the time of her death. The husband went to state Supreme Court seeking an order to control disposition of the ashes of his wife. The husband had sued his daughter and the funeral home who gave her the ashes to get this control back. So according to the court documents, the daughter had stated that she had scattered all of her mother's ashes in Lake George, and then she had thrown away the container. So that in her mind, and her argument was there was nothing to control because it all had been disposed of. So the court heard both parties' sides. And then in their decision, the court actually ruled in favor of the husband, declaring that he was the person who had the right to control disposition of the remains of his spouse. They further declared and directed that the temporary order of protection issued by the Washington County Family Court is not an order of protection within the meaning of 4201 of the Public Health Law, as would disqualify the husband from controlling the disposition of the remains of his spouse. And that even if it is, that a waiver of the disqualification is appropriate in the interest of justice. And then further ordered that in the event that the ashes of the decedent or the box or container in which her ashes were delivered to the daughter by the funeral home should come into the daughter's possession again, then the daughter has to deliver the ashes directly to the decedent's husband. So you might be scratching your head, because I was scratching my head when I read this decision as well. So, but two things to keep in mind. So the court said even if this order of protection was the kind that should bar the husband, that the judge was waiving it in the interest of justice. So he actually used the phrase that the law provides in his decision to give the husband the right to control the ashes. But more importantly, I think, this is my opinion at this point, I find it problematic that the judge interpreted the final disposition law in a way, to me, that clearly is contrary to the plain language of the statute, when he said that the order of protection issue wasn't one that would disqualify the husband. It's an order of protection. The law doesn't get any more specific than that. So in my mind, that was an incorrect decision, but this is another reason why we say how important it is whenever you see a controversy that's not clear-cut way to address, that you pause and get a court involved, because you don't want to be caught in the middle of the situation like this situation that I just went through for you. All right, so that is all of the priority list section. I'm now going to move over to the appointment of agent form. So I'm not going to go through the whole thing, but I did put it on the slide so you could see it all. I've highlighted some sections just because they kind of reinforce some of the things that we've been talking about. It says in the front at the top there, the first highlighted section, that the disposition of my range shall be controlled by name of the agent, right? So this talks about the person in control, which is the person at the highest level. You have a section for special directions. So what you do is if you take the person's being named, and now you put as the person who's appointing the individual specific directions as to what you would like. This goes to that section that I talked about where the person in control, or the agent, if it's the agent in control, should carry out the decedent's wishes to the extent practical and to the best of your belief as to what that person wanted. So if there is a section filled out that has special direction, or I should say, if the special direction section is filled out, then that is something that the agent should be following when they take control of disposition. You'll also see that this section has a area to talk about whether you do or don't have a pre-funded pre-need agreement, and where you can put the name of the funeral firm. That's really just to help the agent find where there might be funds. It does not become a binding situation where that funeral home named has to be the one that provides the services. So all the provisions of 453 of the general business law relating to pre-need are still in effect. In fact, this section of the law specifically says that it does not supersede any of the provisions of the pre-need law. Again, it's just meant to be a place to help the agent find funds. I bring that up because that is a question that we have gotten on occasion. Then comes the point where you address, or you can name your agent. So you have information where you can put that in there. And then obviously you are entitled, as you know, to name successor agents. and the people that you're naming are actually named in priority order. So the first successor agent is the person you would go to if the agent themselves is unavailable, unwilling, or not competent to serve. And then you would have your second successor if you wanted to do that as well. I'm just going to mention also the very last part of that where it says duration, and it says at the very bottom, this appointment becomes effective upon my death. Well, that's kind of obvious, but why do I bring it up? Because I want to mention it again, as opposed to, this is very different from a power of attorney, right? A power of attorney form and a power of attorney is somebody who operates while the person is alive. A power of attorney ends with the person's death. That's when this would kick in, which is why the power of attorney would be able to appoint somebody else in the decedent's place. But that is while they still have the authority to act as that person's power of attorney. So that is pre-need, not at need. At need, if the person dies, you don't go to the power of attorney, you start going down the list from the earlier section that I went through with you. The same is true about a healthcare proxy, which we get questions about as well. If you're named somebody's healthcare proxy, that does not survive death, and you do not get to be the person in control of disposition because you were the healthcare proxy. The only portion of the healthcare proxy that survives is any anatomical donations that the decedent shows. That is the only part of that form that will survive the person's death. Okay. There's also a provision in the agent form, as you all know, where you can revoke your appointment. It's not the only way you can revoke the appointment you made, but you can clearly go back to this and then use the form and say that I'm revoking the appointment. The agent form must be signed by 2 witnesses. A funeral director may serve as one of the witnesses. Again, you just can't serve as the agent if you're being compensated. If you're not being compensated, you can serve as the witness and the agent. Obviously, if you're serving as the agent, you're not going to witness it. You can't serve both roles. But in any case, a funeral director can serve as the witness. There's an acceptance and assumption by the agent at the end, and the person who's being appointed agent signs the form. Why? Because the law wants to ensure that the agent cannot be appointed without both their knowledge and consent. So affirmative action by the agent accepting the appointment at the time they're being appointed is required by the law. So that's why that has to be done. All right, so that covers the form itself. So now I'm going to go into a couple of the other sections that deal with controlling documents. Okay, so if there's no appointment of agent form, you can rely on a will that designates the person to dispose of one's remains and or directs how to dispose of remains. Now, I said in the very beginning, I'm going to read the law, those words from the statute itself. I bring that up because that's how it reads. Why is that important? Because this is different from an executor or an executrix being the person who controls. If my mom dies and I am the executor of her will, just because I'm the executor, if my dad's still living, doesn't mean that I am now in control. I don't jump up to agent status. The only way a will steps up to the point where it's a document that talks about controlling disposition is if it uses language substantially similar to the appointment of agent form. This is what the law is saying, which is this section, what I'm saying right here is, the will designate the person to dispose of one's remains and directs how to. So if the will doesn't specifically say, I direct Kelly Dietz to control my disposition and I would like to be cremated and my ashes scattered, then the will hasn't risen to the level of being the form that you can rely on. If the will has the standard language about pay my funeral costs, that's not enough. That's standard language. The will language itself has to specifically talk to naming the person who's going to dispose of your remains and how you want your remains disposed in order for it to be the document you rely on to name the person who would control your disposition. I bring that up because that comes up a lot as well. The appointment of agent form, if it's executed subsequent to the will, supersedes the will. So again, I might have done a will where I name Kelly, and then I do a form later on where I name somebody else, and that person is going to be the person who is going to control my disposition if I have an agent form that is dated 2022, but my will is dated 2020. Again, as I just mentioned, the most recent written instrument is controlling. As I mentioned on the form, the decedent can revoke a written instrument or agent designation form at any time. Same thing holds true with being able to revoke from a will. So you can either revoke as the person who made the appointment by executing a subsequent written instrument, or by, as the law says, any other subsequent act by the decedent evidencing a specific intent to revoke the prior written instrument. So if you get into a situation where you have something when they're saying this, if somebody's coming to you and saying, nope, that agent was, they revoked that person, they don't have it on the agent form, it's in some other writing, and there's a dispute, we recommend stopping and saying to the family, I need direction from a court in order to move forward, because it's not clear to me, I don't have evidence of where this instrument came from, if that person really signed it, all of that kind of stuff. We always say when there's a dispute like that, pause and ask the family to give you direction from a court. Also, if the spouse or domestic partner is designated as the person who's going to control, that becomes revoked upon divorce or legal separation from the spouse or termination of the domestic partnership. Legal separation is different from being separated. We're separated. We have lived apart for 10 years, blah, blah, blah. But you're still legally married, or you haven't gotten a legal separation, then you're a spouse unless one of those two things are in place. So keep that in mind as well. All right. Moving on. We're getting near the end of the sections of law. There's only a couple of sections left. I mentioned in the beginning there were four reasons why the purposes of the law was put in place. Obviously to set up the hierarchy list, to appoint a form for the agent, which we went over. So now we're going to go over the liability protections and the dispute resolution. So for liability protections, first, a person acting reasonably in good faith and is protected from liability for representing themselves as the person in control of disposition, disposing of a decedent's remains if done in accordance with the law, or identifying a deceased person. So this provision of law deals with the individual who has the right to control disposition and protecting them from acting in good faith if they happen to make a mistake and it wound up being, person wanted to be buried and we cremated the person. But if you really believe that that was their intention to be buried and not cremated, then you'll be protected. On the flip side, the funeral director and the firm is protected from acting reasonably in good faith if you do any of these things. If you follow out or carry out written directions of the decedent that's in the agent form or the will, or you take direction from the person who is representing themselves as the person in control. But again, only when you get the written statement from them that they are the agent, you get that agent form or a will, and they fill in the at-need statement evidencing or acknowledging that they don't know of anybody else who would have rights to control higher up on the priority list. They have no idea that there's a will or other written instrument, and they sign the form. If those folks do that in good, you are then allowed to take action or direction from them and act based on their direction, and you will be protected from any kind of liability as a result of that. And then finally, dispute resolution. So if you can't have it resolved by the people involved, then have it resolved by a court. The law states that. Again, we always recommend to be cautious and do that. A funeral director this is also specifically written in the law, a funeral director cannot be held liable for refusing to provide services if a dispute exists until you receive a court order or a form signed by all parties to dispute, establishing who has control. If you decide to go outside the court way, so let's say, for example, there's two adult children who can't agree on cremation or burial, They later come to you like a week later and say, oh no, we've agreed, now we're going to go with burial. At that point, you say, fine, I'm going to ask you now to sign this form to hold us harmless, and also stating that you have now agreed that you want to bury mom, and have them sign. It doesn't have to be any formal document, but it's something that then you have them signing and dating, and it clearly states that they've agreed to this so that they can't come back after you guys for having relied on what they said. All right, so that finishes the covering the actual law itself. I do have a couple of questions and some answers. So I'm going to give you a question, and then I'm just going to pause for a couple seconds so you can think about if you know the answer, and then I'll show you the answer. So we have 12 questions. So can a funeral director be appointed the agent in control of final disposition? Yes, but as I mentioned, the funeral director cannot be compensated or receive a financial benefit. True or false, the person paying the funeral bill automatically has the right to control disposition. That is false. And as I mentioned, the person with rights is not responsible for paying under the law. Is it possible for a person to be appointed an agent without knowing it? No. As I mentioned at the bottom of the form, it requires the agent to accept their appointment by signing the form at the bottom. Does a person need an attorney or notary public when filling out an agent designation form? This is sort of a trick question because I didn't say yes or I didn't mention this, but the answer is, because I didn't mention it, the answer is no. The only thing that you're requiring to do is have 2 witnesses on the form. Is the funeral director responsible for or required to obtain documentation for proof of a domestic partnership? So the answer to that is no, right? I said that. I wanted to mention something though, and I'm going to go off a little bit here, off script a little, I guess. So the reason why you don't have to by law is because the individual is going to sign the at-need form attesting that they have rights to control. They're going to be saying that they are the domestic partner. You can, under the law, rely on it so long as it's reasonable to do so. So that's where I have that issue with reasonableness, right? You're allowed to reasonably rely on it. If someone comes in and just says, I'm the domestic partner, and you've taken absolutely 0 steps to ask about anything to show that that was the case, that have you taken reasonable steps? I would rather be cautious if I were in your shoes, and I would want to get a couple of things to evidence that. I would ask if they had joint bank accounts, bills that show they were together. Do they have a mortgage together? Is there kids? Things of that nature, just to kind of show that they were living together, and that the person claiming to be the domestic partner has something to show that they really are in that role. Would I ask you to go and prove it? Do you need more than that? No, it's a reasonable step, but it just protects you. So the legal answer is no, you don't have to ask for anything. You can just use the at-need form, and then it's all on them. But anybody can sue anybody, and people will bring you into it. So it's always better in my mind to be a little more cautious and to take that one extra step to ask folks for things that they would have to help them show that the totality of the circumstances exists and that they really are domestic partners. Okay, back to the regularly scheduled presentation. Are there any situations where the designated agent or legal next of kin may not have a legal right to control disposition? Yes. So they are either subject to an order of protection or charged with the homicide of the decedent. Here's a scenario. 3 children meet with you to arrange for their father's funeral. 2 children want dad to be cremated, the 3rd does not. What do you do? Your choices are: majority rules, you move forward. You refuse to cremate because there's a child who objects. You tell the children you can't help them and direct them to another funeral home. You wait and direct the children to obtain a court order to determine who has control. So under that change from 2022, majority rules, and as long as you have 2 of them sign the at-need form saying that they want to go forward, you are protected from the law, under the law, and you can move forward under that new change. Can the funeral director act as one of the 2 witnesses required for the agent designation form? Yes, you can act in that capacity. Of the following individuals, which one has the highest ranking on the next of kin final disposition list? The fiduciary of the decedent's estate, the public administrator, grandchildren, or a close friend or relative who knows the decedent's wishes? I will say this is the hardest one, and I even have to double check myself every once in a while. The answer is grandchildren. They fall under number 7 as one of the highest ranking person who's entitled to share in the decedent's estate. They are number 7. The fiduciary is number 8, the close friend is 9, and the public administrator is 10. So those are the last 4 legs of the list right there. Number 10, true or false? A designated agent can refuse to serve at the time of need. True. And when they are unwilling or unavailable or not competent, you would go to the next person in control per the priority list. Or as we mentioned, if it's someone where there's more people of the same class, you move to somebody else with the equal priority. Are stepchildren considered children when it comes to the final disposition law? No, they are not. And last question, if a couple is separated but not divorced, is the surviving spouse still the next of kin? Yes, they have to be legally divorced or legally separated in order for them not to be considered the surviving spouse at the time of need. All right, that covers everything. So we ended a few minutes early, so we do have time for questions. So I will turn it back over to you, Kel, if there's anybody who has questions for us.
Yes, we do have several questions. So the first question is, what if the mother of the deceased infant is under 18?
So that's an interesting question. I would pause. So the law defines a person as someone who's 18 or older. So putting on my legal hat, I would say that is not the person, the mom's not covered because she's not of age. I would probably, but then at the same time, that's a really tough question. I would probably pause. Oh, geez, I honestly don't know how to answer that. Like, I want to say that the mom would have the right, but I think being under 18, they might not. That honestly would be a question I would probably have to reach out to the Bureau and ask the Bureau if they had a position on that. And if not, I would probably want a legal interpretation. I wish I could answer that one, but that's actually, I've never heard that before, and I really don't know how to answer that one.
Okay.
I'll ask the Bureau, and we can send something out to everybody to let you know what the answer is.
Who has the authority when there's a court-appointed guardian and an agent?
If there's both, then it's an agent. The agent is number 1 on the list. The court-appointed guardian is, I believe, number 6 on the list. So that the agent will always, if there's an appointed agent under the agent form, that person will always have control.
Would a designated executor be considered the agent?
No. The executor of a will is not, if anything, they would be a fiduciary of the estate. They are not an agent. The only way you can have an agent is through the agent designation form or through a will designating somebody but using the language that I mentioned earlier.
If both parents of a deceased are divorced and don't agree on a form of disposition, who would be in charge?
So this goes back to either parent has the rights, but you have 2 people with equal authority who are unable to agree. Our recommendation is to pause and have a court give direction, or if they come back and ultimately agree, to have them sign something that tells you that this is what they want to do and that they're going to hold you harmless. That's what we would say to do. But under the law, if you want to just go black and white by the law, either parent. So you could basically say whoever came to you first is the person that you could work with. And you would be under the law, that would be legal and a way to approach it. we just always decide to tell folks to be more conservative because we know that in many cases you'll get dragged into any kind of legal proceeding that comes because people didn't agree.
I just wanted to jump in with this. I had a funeral director text me and say that he experienced the situation regarding an underage parent,
Yep.
and his response was that a mother is a mother no matter what the age.
Yeah, I mean, that's where I would want to go as well, especially again, if it's, then you're at parent, so that's number 4. So I'm assuming you're not going to have anybody else above, but again, I appreciate that. I just need to, I would just want to confirm that with the Bureau to see if there's anything that they would have to say for that.
Does the New York State agent to control disposition still work if the death is in Florida, but the burial is in New York?
So the form is not contingent upon if the person filled out the form, and I guess the only thing I'm not sure about is are you saying that the person appointing the agent appointed the agent, everything was done down in Florida, but the person is doing things here, the burial is going to be here? I don't think the state, it doesn't matter if the person's out of state, if the form's completely filled out appropriately, and the burial is going to take place here in New York, then you have a completed document, and you should be fine.
Okay, so does the change in the law mean that the priority is not the determining factor regarding who is in charge? In other words, if someone has a spouse, a parent, and siblings, do they all have to approve the spouse's decision about the disposition?
No, so the change in law only applies to people in the same category. So if there's a spouse, since they're number 2 on the list, then the spouse's decisions control. If there is no agent, there's nobody appointed in a will, there is no spouse, and then you get down to children and you have 3 or more children, that's when this kicks in. So if you have to have majority, right? So even if there's 2 children, you have to have you would have majority, so it's 2 or unanimous. If it's 3 or more, you need 2 of the 3. So it only applies to the people in that same priority level when it would kick in for majority, and it's only about them. So if you're at number 3 and it's children, then you're dealing just with the children. If you go down further and you get to siblings, because there's nobody else, then it's just the siblings who, if there's enough of them where you need to deal with a majority. I don't know if that was clear, but hopefully that was.
If a person does their prearrangements with a funeral home and at the time of their passing, the next of kin changes, like burial to cremation or vice versa, what should the funeral director do?
Can you just say that one more time?
Yeah, I'll say it in different, what I believe they're asking. So if a person does their prearrangements with a funeral home, and then when they pass, the next of kin decides to change what the deceased wanted originally, what should the funeral director do?
They should not move forward with that, because the law requires that person to act in a way that's consistent with the known last wishes of the decedent. And since you have knowledge of what the decedent put in their pre-need arrangement, unless they can prove to you that there was a change of heart or of choice by the decedent themselves, then you would be required to follow the law as they would be. And I would not move forward as a funeral director under the next of kin or the person you're working with decision to move differently. I would not move forward because the law does not allow that person to do that. That's similar to the case that I mentioned to you about the children with the mom wanting to be buried in Israel.
if someone is incarcerated, can they still control disposition if they have priority?
Yes, if they're reasonably available, and they don't have any of those other things that, they're in jail, but they're not in jail because they're convicted of killing the person, obviously. That's a disqualifying factor. Yes, they would still be entitled to control if they are the person who's in line.
Okay, let's see that next one. What if there are two children with equal rights?
So if there are two children with equal rights, then, again, the change in law says more than two members. So it says any child 18 or older. So literal, like if I take a literal interpretation of the law, it would mean that you could go with either of the two children. Practically speaking, we would say if you have two children and they don't agree, don't go forward. Get something from a court telling you which way to go, or get them to agree in writing and have them sign something that states what they've now agreed to and holding you harmless. We just feel that there's too many times we've seen where when there's not agreement, and someone starts bringing legal action, that the funeral home gets caught in the middle of it. So the more you can do to protect yourself up front, the better. So again, the legal answer is it says any child 18 years or older, and the change in law basically says that provided if there are more than two members of a class. So if there are two members of a class, you can take either of, and the class happens to be children, then you can take either one of them. But our position has always been, if you have two of them, they don't agree, then don't move forward unless you get direction from a court telling you which way to go.
When a member of a religious community passes away, and there is a, quote, community life team who handles all funeral arrangements on behalf of the community, and the nearest living relative would be a sibling and no agent, how can the religious community act on behalf of the member of their community, whether it be a priest, nun, friar, etc.?
They shouldn't be if there is a sibling who is reasonably available. The only way that it would come to pass where the sibling or the community leaders could do it is if you contact the sibling, or let me put it this way, the two ways. One is the sibling's not reasonably available, unwilling, or not competent, in which case you go down the list. And if you go down the list and there is nobody left except a person willing to act on behalf of the decedent or someone who is a close friend who's reasonably familiar, I don't think you would fall in the category of close friend here, but who knows? You're talking about the last two levels of the priority list. If there's nobody other than that sibling, the sibling does not get involved, or the sibling signs a waiver of their right to control, then that's the only time that I could see where legally the community leaders from the religion could take over control of disposition in this case.
And I know we've discussed this a couple times today, but if a person has more than one child, do all of the children have to sign the authorization for cremation disposition form?
So we've changed, we've asked about that. We've asked the Division of Cemeteries about that with their form. They have not changed their form yet. They've kind of said at this point that it's not, or there are form, as long as we have someone who's authorized. So the way we are approaching it right now is if there are more than, say there's 3 children and you get 2 of the 3 to agree, or even all 3, our at-need form includes signature line space now for all of them. As long as one of them who signed that form is the one signing the cremation authorization form, you're fine. Because they're not requiring that everybody sign that form, just one of the people authorized.
Do you have to provide the crematory proof if they initial that they are the designated agent of the deceased in a will or written instrument executed pursuant to Public Health Law Section 1401?
Not that I am aware of, no.
On the appointment of agent form, are the two witnesses witnessing the agent, the person appointing the agent, or both?
They are witnessing, I will say they are witnessing, I never really thought about it, but legally going through the where the witnesses are. If you look at the form, the witness signatures are above the signature of the agent accepting. So they are witnessing everything above their signature. And that is the appointment of the agent by the decedent, any special directions that they give, then that's what they're witnessing, everything above their signature. So they are not witnessing the agent accepting the form.
Would you ask a domestic partner for documentation if they are looking for cremation?
I would ask a domestic partner who claims to be a domestic partner for documentation regardless of the type of disposition that is being considered or requested, because what we're really doing here is just taking reasonable steps to ensure that they are a domestic partner so that they have rights to make any choices that they want to. So I don't think it matters in terms of the type of disposition. It's really just to protect you, to show that you've taken reasonable steps to know that that person, or at least assume that that person is being honest with you when they say they're a domestic partner.
If a funeral director is named agent, is financial payment to a funeral director considered payment if named in a specific estate or will?
I'm sorry, say that one again, because that one got me.
Yeah, so I think what they're asking is if a funeral director is named agent,
Mm-hmm.
and they're also named in the estate or will, is that considered a financial payment?
Oh, they're a beneficiary of the will. So no,
Right.
if you cannot be compensated for your role as agent. If you are a beneficiary in the will, that is something completely separate and it has nothing to do with your role as the agent. So it would not be a conflict.
Can someone who legally lives outside of New York, but who will be interred in New York, complete an agent form? Is the form valid?
Yeah, I have never heard anything that said where you live or where it's being filled in has any bearing on whether or not it's valid. So as long as it's completed properly, I do not know of anything that says you have to be physically in New York at the time it's completed in order for it to be, and a resident of New York itself in order for it to be valid. So I think it really depends on more of if you're working with a funeral home in New York State, you're giving direction to the funeral director to act, and they're carrying this out in New York, and that's where it really lies. So the physical location of the folks and/or their residency at the time they're completing it does not come into play as far as I know, but I am also going to confirm that with the Bureau just because I've never specifically asked that for that confirmation before. So when I ask about the infant child and the under 18 mom, I'll ask this question as well.
If a wife appoints her husband as agent and then gets divorced, does that automatically cancel the husband as agent?
Yes. As soon as you're legally divorced, it automatically revokes your standing as spouse. I'm sorry, as agent. Say that again.
As agent, yeah.
Okay. If you've appointed the person in your agent because they're your agent, it's not just because they're serving as the spouse. Let me just double check that. Make sure I'm not misstating what I'm saying. 1 second. Yeah, so If it's the spouse because they're the spouse, then that is, hold on, I'm just trying to read the law itself. If the spouse is, once you are divorced, if you were the person in control because you were the spouse, and that's revoked. If you signed an agent form naming the individual who happens to be your spouse, you are not, I don't believe you're automatically revoked on that, although, yeah, that one I'm not 100% sure about either. I'm gonna have to, I'm sorry, I don't want to hold it up, but I don't have it like the answer right here in front of me.
Okay, I'll go. Are successors required to be listed when filling out the at-need disposition form?
A successor agent would not have to be listed unless there would be no reason for that unless, I mean, if you're doing the at-need form and the successor is the one who is filling out the form, then they would be listed on the agent form as a successor. So they would, I'm not sure I'm following I'm not understanding the question correctly.
If someone is the POA, can the POA fill out the agent form and appoint others to handle the wishes without the person physically signing and knowing if they are not in the right state of mind?
If the person, say that again.
So can the
if the person's a POA, can they appoint somebody else as agent even without the individual they're appointing on behalf of, knowing because they're not of sound mind?
Right. So can a POA do that?
Yeah, I mean, that's the whole point of the POA. They're stepping in the shoes. So as long as it's pre-need and they're not appointing themselves, then they can serve in the capacity of appointing somebody else. The individual themselves, the whole point of the POA is they're not capable of being able to act on for themselves. So you don't need them to sign off or to be able to say that they know what decision you made.
A deceased veteran prearranged with us for a cremation, which was fully paid for. Appointed agent no longer wants control of disposition. There is no family, to our knowledge. The public administrator will not take the case due to the funds in the prearrangement. Who would be next?
So the only person left on the list after public administrator, and it's kind of equal to that person, is anyone willing to act on behalf of the decedent. So it's anybody who would be willing to come in and sign the form saying, the at-need form saying they know of nobody else who's willing to take control. That's the last one on the, I mean, basically that's basically saying anybody. So that's where.
Could the funeral director?
I mean, the funeral director, I believe they could. I think that's happened in very rare occasions. If you have a pre-need filled out, you have all the wishes, nobody else is willing to step in, the public administrator's not willing to step in, you've taken reasonable steps to find somebody else. At that point, really, I think you could move forward and be protected based on all those steps having occurred already. So, but obviously if you're acting in that capacity, and somebody shows up out of the woodworks later, they could always claim that they were available and you didn't try hard enough. So I always hate to give a definitive answer because I'm always putting my legal hat on about what if scenarios. But if there is literally nobody else on the list, you've gotten all the way down to the public administrator, they're not willing to act. The only category of people left is the one that says anyone willing to act on behalf of the decedent. And again, that's where you sign the at-need form saying you know of nobody else. So if it happens to be the funeral director, I would say put it on. If you did that, say I would have just something that shows the steps you've taken, notes in trying to find other people. I'd ask for something in writing if you don't have it already from the public administrator saying they're unwilling to step in, and explain that you're doing it because it's a pre-funded, pre-arranged funeral and there was nobody else, including the public administrator, who would step forward. And then I think you were acting reasonably and should be protected if anybody did show up down the line.
The next one's easy. If a couple are separated and each have new partners, who would have control of disposition?
If they are not legally separated or divorced, then the person who has control is the spouse, even if you have new partners. So it all comes down to, are you legally separated or divorced? And if you aren't, then your spouse is still your spouse. And again, I think it's important to note like that, you know, at any point, as you know, if somebody doesn't want to have you, just because like in that situation, it's very possible that the spouse doesn't want to have control or wants to give control to the person that their former spouse was with. Currently, that's you know, you can always do that and waive it, but if you want to go back to who has the legal right, then it's unless you're legally divorced or separated, it's the spouse is still the spouse.
What if an adult child disagrees about disposition with someone who could claim to be a domestic partner?
Well, so then you have an issue where you have someone who the dispute is now between people of different priority levels. If the person's claiming they could be a domestic partner and now you're dealing with that, again, I would take reasonable steps. If you find that it's, you know, they can't even produce anything, you could then just say, well, I don't have evidence of this, and go to the child, down to the child. However, again, being the conservative folks that we are here at the association, I would say to you, if there's a dispute and the possibility exists that this individual could be the domestic partner, then, and they're not agreeing with the child, then I would pause and say, I need a court order to tell me whether or not you are a domestic partner under the law and would have control. Because barring that, then the child could come back and say, nope, this was never a domestic partner. You should have known that, and come after you. So I would not want to get in the middle of that. And I would again pause and have a court tell me which way to go.
Does the change in law saying majority apply to cremation and burial, or just cremation?
It's any form of disposition, so it's both cremation and burial.
Okay, and we've asked this before, I believe this, yeah. Would a New York agent appointment form apply to an out-of-state resident if a New York funeral home is involved?
I would say yes, but again, I'm going to confirm that. And before you go to the next one, Kelly, just I found the section of the law with regard to the question about if the spouse is the designated the agent, and then they're divorced, is the agent form automatically revoked? And the answer to that is yes. So it specifically says the designation of the decedent's spouse or domestic partner as an agent in control of disposition of remains shall be revoked upon the divorce or legal separation of the decedent and spouse, or termination of the domestic partnership, unless the decedent specified in writing otherwise. So if the decedent after the divorce reaffirmed their decision to have their ex-spouse, former spouse, control, then the agent form is automatically null and void upon the divorce or legal separation. So that's the answer to that one, at least.
All right, and someone is asking to revisit the pre-need question. How closely do they have to follow it exactly? Can any changes be made? And if they are made, can we have the family sign a hold harmless agreement?
So yeah, I mean, you have to take into consideration the circumstances on the pre-need, like if it's supposed to be carried out to the fullest extent possible. If if there's something that the family can show that says, they've changed their mind, they're, for whatever reason, and they can show that and they sign off. I think if they sign off and hold you harmless, then you move forward. The worst thing that's going to happen there is that another family member or somebody else is going to come in who had the same level of priority or higher priority and come out and say, this was not their intentions, you lied or something along those lines. But at least at that point, you as the funeral director are protected because you've taken those additional steps. So I would, encourage them to follow it to the closest extent possible, unless they can demonstrate that the decedent had changed their mind and really didn't want this anymore. And in any case, I would always have them sign a hold harmless, just to provide that extra level of protection.
Is the court system where you would get a public administrator from?
So the public administrator is like, yeah, I mean, you could go there and ask. It's usually at the county level. There's a public administrator through, and you might do it through, I would go to your county, like office building, you just say public administrator for your county, and they should have an office. Sometimes they work with the surrogates court as well, but I would just basically go to my county executive's office and search for the public administrator's office for the county.
And the other questions that are left are not in direct relation to this, so I will throw them out. Has there been an update as to when the $20 permit fee will end?
So we don't have an update other than to say that there has been no indication to us of any concerns about signing the bill. The way the process works is that after bills are passed by the legislature, the governor's office calls them over in batches to be signed. They were generally going through until midsummer, and then when the election season started, campaign season, they were pretty much on hold and didn't ask for any. So now that the elections are over, we're anticipating a lot of bills will start to go over to the governor's office. So the way the law works in New York, the governor has 10 days after asking for bills to come over to sign them or veto them. If she does not ask for our bill to go over, then as of December 31st, if she takes no action at all, it automatically becomes law on January 1st. So at this point in time, unless she vetoes it, the latest it'll be is the balance of the year, and starting January 1st, the fee will no longer be legally charged. You won't be responsible for the fee anymore. The best case scenario is that they ask for the bill in the near future, sign it, and then some point in most likely December, based on where we are, it'll start to take effect. So we continue to work with the governor's office, advocate for it, do our due diligence. Once it goes over, I'm sure that we'll send out if we need to, we'll send out a call to action and ask funeral directors to write in support of it. But at this point, we have no indication that there's any opposition to it being signed. It's been just because it's an election year, a lot of bills stopped getting sent over. So everything got pushed back towards the end of the year.
And the last question, what is the status of alkaline hydrolysis?
So that is still a active piece of legislation. It has not been passed as of yet. So we continue to monitor it. It could come back in some way, shape, or form, next session. So we're just always monitoring it, but it's not a legislation that's gone forward this past year yet. So it's still sitting out there. It'd have to be reintroduced next year as a bill because a new legislative session, 2-year session, will start after the election. So we'll have a 23-24 election season, or I'm sorry, legislative season session. So they'll have to reintroduce it.
Okay, and that looks like it's it for the questions. So thank you all for attending. Like I said, please allow 5 to 7 business days for us to get your CEU up on your portal and the letters out to you. If you have any questions, please feel free to give us a call. And thank you so much, Mike, for providing this valuable information for us today.
Sure.
Have a
Thank you
great
all for attending.